Welcome back to the Weekly Friedman, your source of the most essential information in the default industry. About a week ago, we released what was possibly the greatest Weekly Friedman of all time, where we discussed some potentially major FAPA developments that were possibly going to bring about some clarity in the world of FAPA. I'm joined again today by Friedman Vertolo partner Zach Gold and senior appellate counsel Stephen Vargas, as there's been some more movement on this front, and they're going to give us some background on the updates and shed some light on where we're going. How's it going, guys?
Good.
Great. Didn't think we'd be back discussing it so soon, but the court's full of surprises.
Neither did I, but I appreciate you both coming back so quickly. Obviously, there's some big movement and some big things to discuss. All right, so Steve, before we jump in, can you just break down why we're here? Like, what's the brief fact pattern of why we're here?
Sure. On October 1st of this year, the U.S. Court of Appeals for the Second Circuit issued in a quiet title action commenced by property owner East Fork Funding against mortgagee U.S. Bank, issued a certified question to the New York State Court of Appeals, the state's highest appellate court, specifically the following: whether and to what extent Foreclosure Abuse Prevention Act amendments, CPLR 203H and 3217E apply retroactively. And this week, the Court of Appeals declined to accept the certified question from the federal appellate court. As a result, the federal appellate court will hear the appeal in its entirety, decide whether and to what extent the FAPA amendments apply retroactively, and also decide whether any retroactive application is constitutional. However, the Court of Appeals has avoided addressing the issue at this time.
And just to make sure we're clear for our audience, what we're saying is the federal court tried to push it to a state court. The state court said, no, you make the decision. Zach, is this a big deal? I mean, we're still going to have a court making a decision.
Yeah, it is a big deal because if the Court of Appeals had elected to consider the question referred to them by the federal court, any decision on FAPA would have been binding on other state courts. So by sending it back to the federal court, they've effectively limited the scope of what can happen here. So whatever the federal court decides to do wouldn't be binding on other state Supreme Courts. It would be persuasive, but it would have no binding effect. So whether the federal court issues a decision that is in our favor or hurts us, it's really only limited in scope here. Certainly, I would imagine a Supreme Court or the Court of Appeals eventually, when they look at the analysis and the framework to which the federal court ultimately decides the issue, they would strongly consider that. It really is not the development we were looking for towards getting resolution, like a big global resolution on FAPA, whether it's retroactive, and ideally a determination as to whether that retroactive application was constitutional.
So Zach, that means if the federal court decides, let's just say it is retroactive or it isn't retroactive or it can be applied retroactively or it can't be, that would then impact any case in federal court. So cases in the future that are brought where FAPA is argued, this would be binding precedent on that.
In the Second Circuit, yes.
Does that mean then that it's possible that FAPA could be retroactive in federal court and not retroactive in state court or vice versa?
Ostensibly, yes. You could have two different courts, two different systems, the federal court interpreting state law differently than another Supreme Court.
But do you also believe then if the federal court decides one way, that really has no bearing on what the state court will eventually decide?
No bearing, but certainly persuasive. And I can imagine that when this ultimately makes its way through the system in the state court, that they're going to look at the analysis, the framework set up by the federal court, and be guided, let's say, by how they analyze the issues.
Steve, do you think this is representative of what will happen in the future? Judges generally like to decide things. Attorneys have opinions. Judges have opinions. So the state court here was given a shot to make a decision. They told the federal court to deal with it, right? One, I guess, do you think the federal court was trying to give the state court the opportunity to make the call? And two, do you think the state court would try to punt on the decision in the future?
With respect to one, the federal court was deferring to the state highest appellate court because in the federal court's estimation, the interpretation of a state law is best decided by the state court. Particularly, they referenced the federal appellate court specifically referenced policy considerations within the state, as well as state law interpreting state statutes. So I think the federal appellate court elected to certify the question to the state appellate court for that reason. They felt the state appellate court was in a best position to determine how to interpret a law written by the legislature of the state. As far as representative or possibility of future decisions, the only hint we got from the State Court of Appeals in yesterday's order was that, quote, under the particular circumstances of this individual case, end quote, the State Court of Appeals declined to accept the certified question. In a vacuum, that suggests if another case came across its desk, let's say another federal case, another certified question presented, under different facts, under different circumstances, maybe they'd accept. With that said, there were 3 other appeals that worked their way through the state intermediate appellate system, and motions were made for leave to appeal to the Court of Appeals on the FAPA issues. And the Court of Appeals denied leave to appeal in those cases as well. So right now, we're 0 for 4, so to speak, on trying to get Court of Appeals determination. However, I do think it's possible in the future you will find the Court of Appeals ultimately finding the FAPA issues, adjudicating the FAPA issues.
Before we end here, anything else important we missed that you guys think the audience should know?
Just, shocking, I guess, that you would think that the Court of Appeals would be eager to get some resolution on this constitutionality issue, because they are going to be soon inundated with motions for leave to appeal. And by punting on this issue, it's certainly not in the spirit of judicial economy, because they're going to have to be reviewing a bunch of motions for people requesting leave to determine the constitutionality of FAPA. So,
yeah, no, it's interesting. Yeah. I mean, it's definitely not what we were expecting.
One final point I have to make is that if the Court of Appeals for the Second Circuit issues a ruling that's adverse, whichever party, whether the mortgage lending industry or the homeowner industry, defense industry, is impacted by the order, it's possible that the losing party could seek leave to appeal to the U.S. Supreme Court ultimately. So, I don't want to get too eager from a legal, legal nerd perspective, but there is an avenue for this case, the East Fork versus U.S. Bank case, ultimately to make its way through to the U.S. Supreme Court. Although it's a remote possibility, just based on the number of cases in which cert is granted by the U.S. Supreme Court, there was within the last few years a case from New York based on New York law that actually made its way to the Supreme Court that was decided in 2021. It was a case in a due process issue in a case interpreting the hardship declaration requirement within the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020. That case ultimately made its way to the Supreme Court. So maybe it's a low probability of this happening here, but it's not impossible.
That decision would then be binding on the state court. So that's a very good point. So if it makes its way up to the Supreme Court, it's now binding on the state. So
Supreme Court, there you go. We need you. Jump in. All right, guys, look, I appreciate it. This is clearly, a very big issue. I appreciate both you guys jumping on so quickly and kind of educating the audience on where we are and what's going on. So thanks for joining Zach Gold, Stephen Vargas, and I on the Weekly Friedman, your source of the most essential information in the default industry. Thanks for tuning in, and we look forward to seeing you next time.